Hello, welcome to EPG Pathshala, the course Legal Literacy. I am Maruk Edenwala, a lawyer, one of your course teachers. The subject, Human Rights, Part 2. In this module relating to human rights, we are going to look at certain terms used on the international platform, that is at the United Nations level. And we are also going to look at the status of human rights in India, more particularly the Protection of Human Rights Act 1993. In the last module, you will recall, we had looked at the Bill of Rights, and 4 United Nations documents were listed thereunder. 1 declaration, 2 covenants, and an optional protocol. In this slide, we are going to try and understand what these different documents mean. A covenant or convention is legally binding on a country that has acceded to or ratified it. A convention has the same legal force as a covenant. A declaration stipulates aspirations and standards which countries desire to strive towards. A declaration is not binding. It is merely adopted by the General Assembly. It lays down the standards which the country should strive towards. If you want to make a provision of a declaration binding, it has to be incorporated in a convention or a covenant. Certain provisions of the Universal Declaration of Human Rights have been incorporated in the International Covenant on Civil and Political Rights or the International Covenant on Economic, Social or Cultural Rights. Optional protocols relate to a particular covenant or convention. It details a substantive provision or lays down a procedure. Optional protocol is also legally binding on a country that has ratified or acceded to the same. Sometimes a country may ratify or accede to the covenant under which the optional protocol has been framed, but they do not ratify or accede to the optional protocol. For example, the Government of India has acceded to the International Covenant on Civil and Political Rights, but it has failed to ratify the first optional protocol and the second optional protocol which has been issued under that convention. Now we are going to look at the different stages that a convention or covenant goes through. The first stage is the adoption by the General Assembly. A convention in its draft form is debated by the General Assembly. Then it is voted upon and adopted by simple majority. Stage 2, signing by countries. Once a covenant has been adopted by the General Assembly, it is open for signing by countries. After signing, the country may ratify a convention with or without reservation. A country may choose to accede to a convention with or without reservation. A convention comes into force once a particular number of countries have ratified or acceded to it. For example, the International Covenant on Civil and Political Rights states that it will come into force once 3 months have passed since 35 countries have ratified it. What is the difference between ratification and accession? An instrument has to be either ratified or acceded before it becomes legally binding within that country. Ratification undergoes through 2 stages. 1, signing by the country, where the country is reflecting that it hopes to abide with the provisions of the convention in the near future. After signing it, the country ratifies it, saying that now it is legally binding within the country. In accession, the instrument doesn't go through 2 steps. The country at the first instance accedes to it, hence the provisions are legally binding from the first instance. Now we are going to see the implications of signing, ratification, or accession of a covenant. Signing. It's an obligation not to defeat the object and purpose of a treaty. Though signing of a treaty doesn't make it legally binding, the country which has signed it should not defeat the objectives of that convention. Ratification or accession. A state establishes on the international platform its consent to be bound by a treaty. Once a treaty has been ratified or acceded, the country is required to follow its provisions within its domestic sphere. Reservation. What do we understand by reservation? Reservation means a unilateral statement, however phrased or named, made by a state when signing, ratifying, accepting, approving, or acceding to a treaty, whereby it purports to exclude or to modify the legal effect of certain provisions of the treaty in the application to that state. In simple words, reservation means that when a country ratifies or accedes to a treaty, they may choose to exclude the operation of a particular provision within the domestic sphere. These aforementioned terms have been laid down in the Vienna Convention on the Law of Treaties 1969. Every treaty has within it a monitoring mechanism. Under each treaty, a treaty body has to be constituted to monitor the implementation of a covenant within a state party. A state party is a country which has ratified or acceded to a covenant. How does the treaty body monitor the implementation of that treaty? 1, by an initial report, and 2, by a periodic report. For example, under the Convention on the Rights of the Child, the treaty body is the Committee on the Rights of the Child. An initial report has to be submitted by the state party within 2 years of having acceded to or ratified CRC, and thereafter periodic reports have to be filed every 5 years. These country reports should be widely disseminated amongst the people. The civil society organization may also submit parallel reports or alternative reports. Parallel reports or alternative reports reflect to the committee what is the actual situation within that country. After the country reports are filed, the committee holds a meeting with representatives of the state party where the country reports are discussed in detail. In conclusion, the treaty body will list what we call concluding observations. Concluding observations stipulate the steps to be taken by the state party prior to filing the next periodic report. Now we are going to look at human rights in India. We must remember that the Constitution of India and the Universal Declaration of Human Rights were contemporaneous documents. Human rights are contained in the Constitution under the chapter of Fundamental Rights and Directive Principles. India became a member of the United Nations when it ratified the United Nations Charter on 30th October 1945. This is a Supreme Court judgment of 1996. It lays down the importance of human rights. Please read it carefully. This judgment basically says that women's rights are also human rights. That women should enjoy the same human rights that are enjoyed by men. It also states that the state should give facilities and opportunities for women to participate in the cultural, social, and economic life without any restrictions. The next judgment, the Minerva Mills Limited versus Union of India. This judgment was passed by the Supreme Court in 1980. The socio-economic rights embodied in the directive principles are as much a part of human rights as the fundamental rights. It very clearly states that it is not fundamental rights but also directive principles which are part of human rights. India is a socialist and a welfarist state. Hence, achieving socio-economic justice is its prime duty. It was initially perceived that it was only fundamental rights, which are negative claim rights or first generation human rights, that fell within the category of human rights. But now it is clearly understood that even socio-economic and cultural rights, which are positive claim rights or second generation human rights, also fall within the category of human rights. But now the line in our constitution between negative claim rights and positive claim rights is slowly blurring, with the Supreme Court having expanded Article 21 to include several positive claim rights, and also with the insertion of Article 21A of the Constitution. In India, the law which deals with violation of human rights is the Protection of Human Rights Act 1993. This is the preamble or the objective of the Act. An act to provide for the constitution of a Human Rights Commission, State Human Rights Commission in states and human rights courts for better protection of human rights and for matters connected therewith or incidental thereto. Section 2, subsection D of the Protection of Human Rights Act defines human rights. Human rights means the rights relating to life, liberty, equality and dignity of the individual guaranteed by the Constitution or embodied in the international covenants and enforceable by courts in India. Human rights are those rights which are enforceable by courts in India. May they be the rights guaranteed under the Constitution or contained in provisions of the international covenant. The next question which one may ask is, are international covenants applicable within the domestic sphere? The Supreme Court has repeatedly stated that a covenant which has been ratified or acceded to by India is applicable within the country, except if its provisions are contrary to the provisions of certain existing laws within the country. What does this Act establish? It establishes National Human Rights Commission, State Human Rights Commission and Human Rights Court. Now let us see some of the functions of the National Human Rights Commission and the State Human Rights Commission. A. Inquire suo motu or on a petition presented to it by a victim or any person on his behalf or on a direction or order of any court into complaint of 1. Violation of human rights or abetment thereof, or 2. Negligence in the prevention of such violation by a public servant. This is one of the most important functions of the Commission. What do we understand by abetment? Abetment is the aiding or inciting of the commission of human rights violation. B. Intervene in any proceeding involving any allegation of violation of human rights pending before a court with the approval of such court. This is a function which the Commission should proactively carry out. It is important for them to present before the courts their impression with regards to that particular human rights violation. C. Visit notwithstanding anything contained in any law for the time being in force any jail or other institution under control of the state government. This function is extremely important. Members of the Commission should be visiting jails and other closed institutions because there are several human rights violations which take place behind closed doors. D. Review the safeguards provided by or under the Constitution or any law for the time being in force for the protection of human rights and recommend measures for their effective implementation. E. Review the factors including acts of terrorism that inhibit the enjoyment of human rights and recommend appropriate remedial measures. F. Study treaties and other international instruments on human rights and make recommendations for their effective implementation. In fact, the Human Rights Commission should also be trying to pressurize the government or request the government to ratify or accede to human rights instruments. The government of India has been very selective in ratification of human rights instruments. For example, it has not ratified the Convention Against Torture. G. Undertake and promote research in the field of human rights. Human rights should be a subject in all educational institutions so that students inculcate respect for human rights. H. Spread human rights literacy among various sections of society and promote awareness of the safeguards available for the protection of these rights through publications, the media, seminar, and other available means. Dissemination of the standard of human rights is also an extremely important function of the commissions. I. Encourage the efforts of non-governmental organizations and institutions working in the field of human rights. J. Such other functions as it may consider necessary for the protection of human rights. The powers of the Commission come to play once an inquiry discloses that the commission of violation of human rights or negligence in the prevention of violation of human rights or abatement thereof by a public servant. Very often, the state agencies do not intervene to stop a violation of human rights. They are as culpable as the person who is committing the human rights violation. 1. Direct the relevant government to make payment of compensation or damages to the complainant. Payment of such compensation is extremely important. It may also be required to be paid at an interim stage. 2. To initiate proceedings for prosecution or such other suitable action as the Commission may deem fit against the concerned person or persons. A Commission cannot penalize or punish the violator, but it definitely can recommend initiation of prosecution against him. 3. To take such further action as it may think fit. 4. To approach the Supreme Court or the High Court concerned for such directions, order or writs. It is very important that the commissions bring to the notice of the Supreme Court and the High Courts the different human rights violations. Very often, the human rights commissions have been described as toothless tigers, but the provisions of the Protection of Human Rights Act has given them several powers. They should be proactive and ensure that these powers are effectively used. Human rights courts. The state government is to constitute human rights courts in every district with the concurrence of the Chief Justice of that High Court. What is the purpose of these human rights courts? To provide speedy trial of offences arising out of violation of human rights. Has every state government appointed human rights courts in every district? Have matters with regards to human rights violation been referred to these courts? Have these courts been effectively functioning? Also in disposing of matters speedily? Social workers should use the commissions and the human rights courts to ensure that human rights are not violated or that the guilty person is brought to book. Only approaching such commissions and courts will enable us to know whether they are functioning properly. Taking matters of violation of human rights to commissions and human rights courts is extremely important because very often the violators, who are state agencies, the police or the army, feel that nothing will be done against them. it is very important to send a message that the commissions and human rights courts are watching. Enforcement of human rights. The legislature, the executive, and the judiciary have an important role to play in enforcement of human rights. Let us first look at the role of the legislature. The main role of the legislature is to enact legislation for protection of human rights, as laid down in the Constitution or under the international human rights standards. 2. Such legislation should contain provisions to penalize state agencies responsible for violation of human rights, for payment of damages and of compensation to the victim, his family, for injury caused, and to create space for civil society to monitor the human rights situation in the country. Such provisions penalizing the person responsible for violation of human rights is extremely important, because only then will the state act in a responsible manner. Today, they continue to act with impunity. 3. The state should take appropriate action on recommendations of commissions appointed under the Commission of Inquiries Act. Every time a large-scale human rights violation takes place, in order to quell people's anger, the state government appoints commissions under the Commissions of Inquiries Act 1952. Sadly, often the term of these commissions is ended before the report is ready, or even if the report is ready and recommendations made, these recommendations are not implemented. It has been documented that commissions that have indicted police officers have been promoted by the state government. Role of executive. To establish the infrastructure and human resources as envisaged under the Constitution and legislation for protection and promotion of rights of the marginalized. We have several laws with regards to the weaker section and the marginalized, but its implementation is zero. It is necessary that the state set up the envisaged infrastructure and appoint human resources. 2. Adhere to democratic principles in its functioning, thereby reflecting interests of all in the society. In its functioning, the executive should be impartial, giving opportunities and facilities and implementation of policies so that everyone's interest is protected. 3. Abide with the standards laid in international human rights treaties and to send timely reports to the treaty bodies. Take appropriate measures to implement concluding observation. Social workers also play an important role with regards to concluding observations. The concluding observations of different treaty bodies should be taken to the people. A campaign should be carried out to ensure that the concluding observations are addressed. Role of the judiciary. The judiciary plays an extremely important role in enforcement of human rights, especially under its PIL jurisdiction. Judiciary should not dismiss PIL merely on technicalities or on suspicion. The judiciary has also played an extremely important role with regards to expanding Article 21, right to life. It should continue including within it different facets that enable a person to lead a life with dignity. The judiciary should also strike down legislations which are unconstitutional or provisions which are regressive and impact the advancement of marginalized members of society. The educational institutions and media also play an extremely important role. 1. To spread awareness on human rights issue. Reflect the impact of state policies, especially those policies which are anti-people and will adversely impact upon them. Create public opinion in favor of human rights. Research and publication on different human rights subjects. It is important that human rights subjects are within the curriculum of educational institutions. The state should take proactive steps to create an environment where the media is able to report fearlessly and freely. We must recall that the right to freedom of speech and expression is a fundamental right under the Constitution and should not be curtailed. In conclusion, social workers play an extremely important role with regards to spreading human rights standards amongst the people and to ensure that everyone's human rights are protected. A reference material is an article by Asghar Ali Engineer, Shri Krishna Commission Report, Will It Be Implemented? It is on the website of the Center for Study of Society and Secularism. Thank you.